I want to talk about DUIs for a minute and refusals of a blood test or a chemical test, and we'll talk about that in a second, and kind of how some things vary so much from state to state. So I'm not a Florida lawyer. I do not have a bar license in Florida. I do not practice in Florida. I cannot give anybody advice in Florida, and this is not advice. This is just information about how things can vary so much from one state to another, okay? So when we're dealing with a DUI, almost always after the arrest, law enforcement is going to ask you, do you submit to a chemical test of your blood, breath, or urine? In Georgia, especially in West Georgia, Coweta, Carroll, kind of where our main offices are, we're going to see a request for blood most of the time. Do you submit to a chemical test of your blood? Okay, you can refuse that. You can say, no, I do not consent, in which case two things happen. Either the prosecution and the law enforcement have to go forward with no blood test, or they can apply for a warrant and take your blood against your will. Okay. There are some things that can happen. If you refuse your blood test, you've got to take action quickly. And if you don't, you're going to get your license suspended for 12 months. You can't drive to work. You can't drive to school. Nothing. Okay. There's ways to prevent that, but that's kind of the default if you do nothing. But Florida recently, a couple of months ago, has taken it a step further. They have actually made it a crime to refuse that blood test, okay? Which is going to be a really interesting, I'm sure there's going to be legal fights about this, about whether or not it is whether you can criminalize someone kind of doing nothing, right? So basically, if the cops ask you for permission to take your blood and you just do nothing, you just don't answer, right? That's going to be seen as a refusal. Can you criminalize someone doing nothing? So someone literally just saying nothing, speaking nothing, making no like nods or shakes, right? Just literally sitting there or standing there and doing nothing. Can the government turn that into a crime? Okay. Now I'm sure the state's going to say, well, this person has chose to drive. They've put themselves in a special situation where we can't, right? But the defense bar is going to say, listen, it's one thing to take administrative action against somebody's license or something, but turning that into a crime is a whole new world. But as a Georgia lawyer, and we handle a lot of DUIs, that's something I'm on the lookout for, right? Is Georgia going to follow Florida's footsteps in this and try to criminalize refusals? If so, we're going to make sure we're on the front line doing whatever we can to fight that and make sure that people maintain their rights not to incriminate themselves. But just something that we've seen recently as a major development in DUI law in the U.S. is Florida criminalizing these refusals. We're going to be on the lookout to see if Georgia starts contemplating something like that. Georgia's legislature meets in January, and we'll make sure we're monitoring to see if there's any changes like that coming our way here in Georgia.